Chair, I can confirm that the recording has started and the live stream has as well.
Okay, thank you. So welcome back to the Aberdeenshire Licensing Board. We're now on item 7, which is an application for a major variation of a premises licence at Greens of Fraserburgh. And the officer taking the report is Fiona Stewart, but we'll just check everybody's in the meeting first. So can I just check that the applicant is in the meeting? I can see Mr. Hazard. Can you just confirm you're there, please?
Yes, convener, I'm here, and apologies from Harris Aslam, the director, who had wished to be here but was unfortunately otherwise detained.
Okay, thank you. Are you satisfied that you've received all the relevant information and feel able to participate in the determination of the application?
Yes, fully satisfied, thank you.
Okay, and I'm looking for Sarah Ward at LSO, but is she with us today? It's Kevin, is it?
Chair, yeah, I'll be representing instead of Sarah. She's
okay.
Unavailable today, thanks.
And are you satisfied you've received all the relevant information and you feel able to participate in the determination of the application?
Yes, I have, thank you.
Okay, and for those joining the meeting, in line with the guidance you've received in the public participant meeting protocol for licensing board hearings, please can you mute your microphone when not speaking if your phone permits this. Please do not speak unless I invite you to do so, and please do not interrupt the other speakers. If you do, you may be removed from the meeting. Once you've been asked to make concluding remarks, you are not entitled to speak again unless to answer a question from a board member. Once the board has made its decision, you will be asked to leave the meeting. If the board requires to adjourn to deliberate the application, the recording of the meeting will be paused and the board will retire to a separate online meeting room. Please wait in the main meeting room until the board members return and I can resume the meeting. At that point, the recording of the meeting would be restarted. I will now ask the Deputy Clerk to introduce the report and confirm the procedure for the hearing.
Thank you, Chair. The sole reason for this application being before you today as a hearing and not as non-contentious is that the applicant is seeking, as part of the major variation, to increase the capacity of the alcohol display area within the store. All other parts of the variation application have been agreed with the applicant and can be granted. There is no evidence before the board to justify the board refusing the entire application in line with the legal test which forms Appendix 5 to the report. This store is located within the town of Fraserburgh. In terms of Supplementary Policy Statement 3 of the board's current statement of licensing policy relating to over-provision, the board has found there to be over-provision in relation to off-sale premises in Peterhead and Fraserburgh. This means that the board has found that Fraserburgh is already over-provided for in relation to off-sales due to the level of potential risk and the fact that there is already a higher than average availability of alcohol within the locality, which, from the evidence examined, has led to a high level of harm. The applicant is seeking to increase their off-sale capacity from 24.6075 metres square to 30.5 metres square, so it's approximately 6 metres square of an increase. The finding of over-provision of off-sale premises in Fraserburgh means there is a rebuttable presumption against any grant of applications for premises licences, provisional premises licences, or variation of premises licences in relation to off-sales. The board has stipulated within its over-provision policy to grant such applications where it considers that the licensing objectives would not be undermined by the specific proposal set out in the application, or that those objectives would not be undermined if the applicant's operating plan were to be modified or the grant of the licence made subject to the appropriate conditions, and that no other ground of refusal other than over-provision would apply. So for the sake of clarity, the board is only being asked to consider the difference of approximately 6 metres square. If the board finds the applicant has not satisfied the board in relation to its policy and refuses this part of the application, the current capacity figure will remain in place within the operating plan attached to the licence. If, however, the board is satisfied that there is sufficient evidence to justify a departure to the board's policy, the board may consider granting the application with the higher capacity sought by the applicant. The procedure is as set out in Appendix 7, to hear the applicant, hear the Licensing Standards Officer, invite the applicant to respond, invite board members to ask questions of either party, invite concluding remarks in reverse order, and thereafter make a decision. And if I could ask Harriet, our paralegal, to share her screen, we do have a map showing the locations of off sales in Fraserburgh with their existing capacities and operating hours. And if she could share that now for everybody. If you go down to the second page. So this is the existing area, and the off-sale hours don't apply here because we're only looking at capacity, and the current capacity within Fraserburgh is 868.03 metres square. And if you go up to the first page, Harriet, the difference is 0.01 metre square if this application is to be granted as applied for in relation to the overall capacity within Fraserburgh. So the dot, I don't know why the map hasn't come up in the second picture, but that just represents exactly the same premises, and it's only the off-sale capacity that we're taking into account here. So as I said before, the total difference, if the board are minded to grant this application as applied for Fraserburgh as a whole, will be 0.01 metre square of an increase. Thank you for that, Chair.
Okay, thank you. So I'll go straight then to Mr. Hazard, and if you want to outline the terms of the application, and you might want to address the concerns raised in the representation at this time.
Yes, thank you, Convener. I'll endeavour to do that. What I've got to do is split my submissions into sort of three broad headings, just to give you an introduction to the applicant, so you know who you're dealing with, go through, as you've suggested, the application, and then tie in the issues regarding over-provision, how they uphold the licensing objectives, and my views just on the application as a whole. So in terms of Greens Retail, they're a multi-award winning chain of 27 convenience stores, and that number's increasing as they expand across Scotland. Not just convenience stores, they're convenience stores often with post offices and some takeaway food as well. They've recently gone into partnership with Iceland and Dundee, and they've also got a partnership with Pizza Hut. They presently have 4 stores by my calculation in Aberdeenshire. They're in Inverurie, Ellen, Peterhead, and of course Fraserburgh. And across the 27 stores, they employ north of 350 staff in front of house, back of house, and that number is, of course, increasing. The individual offer in each of the various stores does vary slightly, but my submission, it's consistently high quality. The stores themselves are high quality, bright, modern, accessible, and they feature an extensive range of grocery, fresh, frozen, all the things you would expect, household products, food to go, coffee to go, and so on and so forth. In Fraserburgh, which was a former co-op, they also have butchery and bakery offers, and it's more akin, I suppose, to a small supermarket, such as the wide range of products available. You could really do quite an extensive shop in the Greens Retail stores. Saying that, alcohol is very much ancillary to the other products sold in the stores, and in this store I asked for the sales breakdown. It equates to some 13%, so 87% of what's sold there is not alcohol. So it stands against the backdrop of what I've said about alcohol sort of being ancillary. The application, which, as your clerks very helpfully pointed out, tidies up a couple of other non-contentious matters, shop radio and so on and so forth, is very much before the board due to what I would describe as a modest request for an increase in the alcohol display policy, in the alcohol display capacity, beg your pardon, which obviously triggers the board's over-provision policy. As has been set out in the report, but just worth underlining, the policy creates a presumption against the grant, but that's not an absolute refusal outright. For the policy to be lawful, each application is to be considered on its own merits, and there must be room for exceptions to the policy. And I'm pleased to say that the board obviously recognises that, and it's for us to provide a justification and some evidence as to why the board's over-provision policy wouldn't be imperilled by the grant of this. I suppose the best place to start is perhaps with reference to the 5 licensing objectives. What you have here in my submission is a very responsible and, as I say, award-winning retailer. They provide modern convenience stores. With that comes everything you would expect to see. So just trotting through, and I'm not going to go through this ad nauseum, but a few examples in relation to each of the licensing objectives. Preventing crime and disorder. All the stores are fitted out with state-of-the-art CCTV. All the tills are the state-of-the-art tills, so they recognise age-restricted products. They're programmed so that alcohol, if scanned out with alcohol hours, obviously couldn't be sold, and so on and so forth. And staff are trained in their responsibilities in relation to the sale of alcohol. In addition to the standard training, the 2-hour mandatory training, the company do have a refresher program in place, and I'm told that they've recently employed an accredited trainer in-house who's refining all of their in-house training, and will in the coming months be delivering a brand new training package across the entire estate, which will include Fraserburgh. And of course, in relation to crime and disorder, all alcohol not for sale is stored in a locked fast store. Public safety, full risk assessments are in place, as you would expect. The stores are very well staffed. I'm sure you'll be familiar with some convenience stores, single staffing just doesn't happen here. There's some 11 staff in this store, and a mix of full-time and part-time contracts. So my submissions, the stores are always very well staffed and supervised. And in relation to security and other matters, it's all kept on a rolling risk assessed basis. Public nuisance, not something generally associated in my submission with convenience stores, but very much these are community stores, and I know Harris and the team there at Greens, they do a lot of outreach in the community, they do a lot of charitable work in the stores. It's not uncommon for them to have people on spin bikes raising money, so on and so forth, and they very much do take on board any concerns that neighbours raise. None I'm aware of in this store, and obviously they've got all of the processes in place for waste tidying up in the area, etc. In terms of improving public health, perhaps one of the most difficult ones for convenience retailers, but as a significant member of the Scottish Grocers Federation, Greens engage in all the healthy eating initiatives in store. They promote all the fresh products that are for sale, and the stores are very good at displaying drink-aware material, having refusals registers, etc. Not just for underage sales, but staff are trained to spot the signs of overconsumption and refuse service accordingly. And finally, in relation to protecting children from harm, as you would expect, the staff training focuses heavily on Challenge 25, prominent signage on display, and it ties into the till systems. So in terms of the sort of policy requirement to ensure that the application and the applicant wouldn't cut across the licensing objectives, I hope I've given you some comfort there. And then we turn, I suppose, to the nub of it, which is the capacity increase. In terms of the board's policy, this is a modest existing alcohol display in my submission, and should you be minded to grant the application, it's a fairly modest increase that's being sought here. I note with interest that the policy itself highlights that the mean average capacity in Fraserburgh is 39.8 metres squared. The store is below that and would remain below that, and indeed it would actually align more properly with the Aberdeenshire average. So in terms of context, often I'd be saying to boards, my experience or my understanding of the Greens estate is that 36 is about relevant for this size of store, but actually it sits quite comfortably within those average that you would see. Why do they want to do this? It's absolutely not a stack it high, sell it cheap model that they adopt. Convenience pricing tends to be slightly higher than supermarket pricing, etc. What they're really trying to do is create a situation where the range of products available in Fraserburgh is similar to the range of products they have in their other stores. It's not stack it high, it's not more of the same, it's about providing a slightly wider range of beers and wines. This is in the accessible alcohol area. So it's a slightly wider range, respond to customer demand. They put a big emphasis on working with local producers through the butchery, the bakery and so on and so forth, but also through their alcohol sales. And they like to stock local craft products where they can, and they need a little bit more space in order to do that. In terms of the final point I would make is, overall, and it was quite helpful, I hadn't appreciated that the statistical information that was presented at the start by your clerk and paralegal, but ultimately in my submission it would be a fairly de minimis impact on the overall alcohol availability, and thus again I think taken in the round with the comments I've made about the protecting licensing objectives, I don't see how a 0.1% increase would challenge or create any negatives in relation to this particular store, this particular application. There have been no objections I'm aware of to the application, which again I would point to. Doesn't seem to be any wider concern about the operation of this store. And on that basis, subject to any questions you have for me, I would be seeking the grant of the application as sought. Thank you.
Sorry, muted myself. Thank you. Can I ask Kevin MacDonald, please, to speak to the LSO representation, please?
Good afternoon again, Board. Yes, the representation from Sarah Ward is purely in regard to the increase in capacity, which takes it into the realms of the Board's over-provision policy. Everything else is in order. The conditions have been agreed with the applicant, and Sarah confirmed that the site notice was signed and on display as required. There's nothing further from the LSOs other than to highlight that it does take it to the over-provision.
Okay, thank you. Mr. Hazard, is there anything you want to add, having heard from the LSO?
No, thank you, Convener.
No. Okay. So open to questions now to board members. Mr. Taylor, please.
Thank you very much, Convener. Mr. Hazard, good morning. You very eloquently explained Green's situation. I should just like to comment about there's a significant wholesale area, which I presume will be Lockfast, for all goods, and some of that will no doubt be for alcohol as well. So I'm just making sure that there's sufficient storage there for you to be restocking alcohol within the existing area.
Thank you. Yes, I can confirm that per the board's conditions, alcohol which is not on display is stored in Lockfast safe, and that is sufficient. Even if the board were with me and minded to grant the modest increase, that there would be sufficient capacity to store alcohol.
Okay, thank you. Fiona, do you want to come in? I saw your hand go up.
Yeah, it's just to say that the alcohol storage has been looked at across the application as a whole, and everything is in order, but also to say that the legislation is not in relation to wholesale sale of alcohol, only retail sale. So you're looking at what can be sold from within the premises that's already licensed, not the storage area beyond that. So the officers are satisfied that the application meets the board's policy requirements in terms of the alcohol storage, and all that you're being asked to consider here is the increase in capacity against the over-provision policy.
Okay, thank you for that clarification. Mr. Goodall, please.
A question for Fiona, I think, regarding the policy. If we depart from policy in this case, I would hope that would not, how could I put it, strengthen the arguments of other retailers in the area taking the same methodology and applying for an increase in their acreage or area, their square meters, which may lead to, although this is a very small addition, if everyone else takes this tact, we may end up with a large expansion. So
can I just stop
some
you
advice on
there,
that?
Jeff? Can I stop you? We're just at the point of questions for Mr. Hazard or the LSO.
My apologies, I'm not feeling too good and I'm all over the place.
That's okay. Any more questions? So I think the obvious one, and you did touch on it, Mr. Hazard, was the reason for the application was so they could stock a wider range of products. It's not more of, it's different. Is that right?
Yes, absolutely. So in terms of this, and this is not exclusive, but ultimately in terms of all retailers are looking at the range of products that they sell. So it's the types of beers and wines predominantly in this accessible area they sell, also incorporating an increasing demand for low and no alcohol beverages in these areas. And it's just really allowing sufficient shelf space to have that range which customers would reasonably expect. And if, for example, you're on holiday in Aberdeenshire and you are familiar with the greens in Fife or wherever else it may be, and you go in, you see similar ranges of products that you would see in your local greens retail. It's a bit of consistency across the brand.
Okay, thank you. So if I were to go into the local one here in Inverurie, they would have a bigger range at the moment.
Well, quite, yes. And I think in terms of looking at that, one of the things which I've been at pains to understand as someone who's represented greens across the country is that it won't be identical because they do try and harness connections with local suppliers. So what you might find actually is in Aberdeenshire, there might be a couple of local beers that you wouldn't necessarily get in Fife because it'd have Fife local beers or so on and so forth. But yes, in terms of the breadth of range, the amount of choice you have, they won't have a consistency across that. So if you go into Inverurie, or if you go into Peterhead, if you go into Fraserburgh, depending on the store size, any store of this size relative would have a similar size range and you wouldn't be disappointed.
Okay, thank you. Are there any further questions? No, don't see any hands up. So do you want to say anything in closing, Kevin?
Apologies, my microphone was off. No, nothing further, thank you.
Okay, thank you. Mr. Hazard, do you want to say anything in closing?
I'll keep it very brief. The final remark would be in relation to this. I think the central submission is it's a very small, modest increase. Is there actually genuinely any nexus between what's being asked for and any potential for harm? And in my submission, that there simply isn't, and I would move the grant. Thank you.
Okay, thank you. Do board members require any legal advice from the clerk before we go on? Mr. Goodall, please.
My question to Fiona again. Do you want me to repeat it?
No, I got the gist of what you're saying, Mr. Goodall. Each application has to be considered on its own merits, is what I would say. With regard to other retailers coming forward, as you saw from the statistics, overall, if you are minded to grant this application, it's only a 0.01 metre square increase, so it's a very small increase across Fraserburgh as a whole. So you may find that this doesn't have an impact. You may find otherwise. Future applications, the more that come before you trying to do the same, will increase that 0.01 figure. So you will get to the stage where the policy would have to fundamentally be reviewed, but we're not there yet. You have granted similar applications on new premises licenses in Peterhead with quite a large breadth of range, but not in terms of volume of alcohol. So what I would say is don't be afraid of future applications. Deal with them if and when they come in on the merits of their case against your current policy, and just look at, has justification been provided by Mr. Hazard today to allow you to make a departure to policy? And are the harms, alcohol harms identified in your policy further undermined or exacerbated? Or is the way that the premises operate and what they're trying to do here promote and comply with the licensing objectives so that it doesn't undermine those identified harms at the moment and would allow you to grant? So don't worry about potential floodgates or future applications. You'll deal with those on an as and when they come before you basis and focus on what you got before you today. As long as you've got a reasoned decision for your decision today, that you've done what you're here to do, Mr. Goodall.
Okay. I take it a nod means that answers your question, yeah.
Yes, I'm trying to save my voice. It's not doing very well.
Mr. Taylor, please.
Thank you, convener. Discussion lately was around range, which I think is commendable. But the detail of my question is in terms of the zero alcohol beverages. And I just want to clarify from Fiona, these would be outside the licensing objectives, and indeed outside the area, area that they would be displayed outside the alcohol area that the shop is using.
In theory, you would think so, particularly with no alcohol, but low alcohol is still alcohol under the Act. And what you tend to find across all of sales, particularly of this size, that the way their tills and their Challenger 25 is set up and the way that they display their alcohol, the low and no alcohol is contained within the same area as the alcoholic beverages, and the Challenge 25 and refusals register still applies. So I totally get where you're coming from, Mr. Taylor, but in reality, although it's low and no alcohol, it's treated in the same way as an alcoholic beverage, so that it simplifies basically the refusal and ID systems within these stores. Speaking as somebody that can't drink alcohol at the moment and has to go and find their low and no alcohol, then you find it within the alcohol display area, just the same as the alcoholic beverages. That's the reality.
Okay, thank you.
Same thought was going through my mind, Ian. So I was thinking the same thing. So no other questions or advice from the clerk? Okay, Fiona, can you just outline the terms of the legal test here?
Yes, thank you, Chair. Again, I would reiterate in respect of the rest of the application is non-contentious and should be granted. And the grounds of refusal are set out within Appendix 5 of your papers, Section 5. And again, I'll advise whether or not they apply or don't apply. A, that the application must be refused under certain sections of the Act. That does not apply to the board today. B, that the Licensing Board considers that the granting of the application would otherwise be inconsistent with one or more of the licensing objectives. Potentially that ties into your over-provision policy because you have alcohol-related harm which shows up under the prevention of crime and disorder and protecting and improving public health. But that's part of a separate ground of refusal for over-provision. So I would say this directly does not apply today. C, that having regard to the nature of activities, location, character, condition and the persons likely to frequent, the board considers the premises are unsuitable for use for the sale of alcohol. I'd say that does not apply here, and that your main focus, and again, it's only in relation to that approximately 6 metre square increase and not the existing capacity, is that if the application for variation were to be granted, there would as a result be over provision of licensed premises or licensed premises of the same or similar description as the subject premises. So D is the relevant ground of refusal. You're considering this in terms of your policy and whether or not Mr. Hazard has satisfied the board that there are good reasons to allow you to depart from policy and grant, or if you feel there are not sufficient reasons to refuse, but the increase only, and the existing capacity would remain on the licence. I hope that's clear.
Okay, thank you. Do members wish to retire to deliberate? No. Okay. So in that case, I can open the debate. Ms. Black, please.
Thank you very much, and thank you for a really thorough introduction there, Fiona, giving us all the outlines, and also to the agent for his detailed introduction too. For me, this is about the fact that it's an extension of what is already there as opposed to something that is brand new when it comes to our over-provision policy, because that's the only thing we're really considering here. If it was a new application, a new area where there wasn't one existing, then it would be a totally different story. But the fact that you gave us those stats, Fiona, on the fact over the whole of Fraserburgh, which is the area we're looking at for over provision, it only actually equates to a 0.01 metre square increase. That is really insignificant, essentially. And that context that was given by the agent, that they're basically wanting to increase the range that is offered, which matches what people would expect from a greens, when they've got experience of greens in other places. Means I'm using that as part of the weight, and the fact that the LSO has only actually referred this to us because of the over provision policy. If it was anywhere else, it would not have been coming to us. It would have been accepted as is. So that context is really important. So yeah, the fact that it's not new and it's just a small increase in one place for something that already exists, I would be inclined to go towards granting this.
Yeah, thank you. I think I would agree with your comments there. Mr. Taylor, please.
Oops, I'm hoping I've pressed the right button and you can hear me okay?
Yes, you're fine.
Good. I find this case quite difficult, actually, in the sense that one side of me appreciates what the agent has said, and indeed what Miss Black has commented about. And another side of me thinks in terms of, yes, it's only 6 square metres more, but it was 24 square metres-ish, so it's at plus 25%. So it's a bigger figure than the 0.01 square metres for our provision in the town as a whole. There was comment too that alcohol was an ancillary aspect of the shop at 13% of sales. So it's not just a high proportion. And there's a little bit of concern in terms of a little bit of creep, but you know, we will consider each application in its own merits. So as I say, it's a difficult one in my mind, but I'll just make these 2 points at this particular stage. Thank you very much.
Okay, thank you. Anybody else want to come in on the debate? Any points to raise? No. So in that case, can members just confirm you've received sufficient evidence upon which to make a decision?
Yes.
Yes.
Yeah.
Yes.
Yes.
I would say and some, because we've had all the data to look at as well. Can I call for a motion at this point? Ms. Black?
Yeah, I'm happy to raise. Sorry, I'm happy to raise a motion based on the comments I made earlier to grant this application on the basis and to deviate from policy on the over provision policy on the basis that it is a minimal increase of an existing area within Greens for that context of increasing their range to match what is expected of a green store.
Okay, thank you.
Is that enough, Fiona? Yeah, okay.
Are you seconding, Mr. Menard?
I certainly am, yeah. The agent has given me sufficient evidence to grant a departure from policy and have no problems with that.
Okay, thank you. Is there an amendment? Mr. Taylor?
Yes, I will put forward an amendment that the 25% increase in area that I spoke about earlier will result in over provision, and for that reason I'm going to suggest that it should be returned. It should be refused from a point of view of over provision in the locality.
Okay, thank you. Fiona, do you want to come in before I go for a seconder?
Yeah, Mr. Taylor, there you said that 25 increase will result in over-provision. I think you need to rephrase that, because the board has already found Fraserburgh to be over-provided for. So you're either satisfied that Mr. Hazard has given you sufficient information to justify a departure from policy to allow the increase to be made, or you're not satisfied and you need to identify why you're not satisfied, that they've met the rebuttable presumption, and therefore that part of the application should be refused because over-provision already exists. It's not the case that granting this will make Fraserburgh over-provided. Your policy has already found Fraserburgh to be over-provided. So are you satisfied that Mr. Hazard has met the rebuttable presumption and given you evidence to grant this extension to the capacity, or are you not satisfied and therefore the provisions of the policy remain and that part of the application should be refused? That's the basis that you need to frame your amendment around.
Okay, Mr. Taylor, do you want to come back in?
Yeah, based on what you've said, I'm going to need to accept that he has made sufficient argument and to allow me to force me to withdraw my comments. Thank you.
Okay, thank you. So there is no amendment unless somebody else has got an idea. So in that case, would the decision be unanimous then? I'll just go over to Fiona to go over the decision first.
So the decision as proposed by Ms. Black, seconded by Mr. Maynard, and if I can get my mouse to work, is that the applicant has justified a departure to policy on the basis that it's a very minimal increase to an existing store, and that therefore this part of the application should be granted as applied for. So can I ask, is that unanimous? I'll take silence as unanimous. And obviously the rest of the application is non-contentious, so I'm taking it that you're happy with that. So Mr. Hazard, your application has been granted as applied for today, and you'll get written notification of that within the next 7 days.
Much obliged. Thank you very much, Your Honours. Thank you for your time.
Okay, thank you. So I can confirm that this hearing is now concluded, and thank you for attending today, Mr. Hazard, and thank you for your interest in this business, and I will now ask you to leave the meeting.
Thank you.
Okay, so now we go on to the item 80, which is the Licensing Scotland Act 2005 fees review. And is Martin Ingram in the meeting? Yes?
I am indeed.
Okay, can you speak to the report, please, Martin?
I can indeed, Convener, thank you. So board members should have before them the report, which is to ask the board to consider the materials before them to agree to a formal consultation on proposed changes to certain licensing board fees as detailed within the report. And in Appendix 1, it is proposed that that consultation would take place during the month of November. It simply would begin on the 3rd of November because that's the start of the working week, and it would be running through until Sunday the 30th of November. Thereafter, officers would take cognizance of any consultation responses that have been received from the public, and it would be proposed that we would be looking to bring those consultation results back to the licensing board at their December meeting, and the view thereafter would be to implement any changes should the board be agreeable to doing so from the 1st of April 2026. So these would be fees that would be implemented for the financial year 2026-27. And thereafter, in addition to that, we would be looking to implement inflationary increases for any years thereafter. So that would be implemented from the 1st of April 2027 going forward. There's just a few things I would want to highlight to members at this particular stage. First of all, just to confirm that the methodology that we've applied in relation to the reviewing of the licensing fees. We have tended to take the approach of reviewing this on every 3 years. So we have had previous reviews of fees in 2019 and 2022. And the approach that's been taken in relation to this fees review is the same as it has been for the previous reviews. You will see from the report at paragraph 3.4, we reiterate the provisions of Regulation 13 of the 2007 regulations, and that in respect of determining those fees, that we have a discretion to set. Obviously, as provided for earlier in the report, there are certain liquor licensing fees that we do not have a discretion to change. They are set by statute, but in relation to the ones where we do have a discretion to adjust those fees, we are looking to, broadly speaking, ensure that we are covering any costs that are required in order to meet that. So in terms of the approach that we've undertaken, we have looked in relation to the licensing fees. There are obviously some licensing fees which are essentially simple or non-contentious, which will not be as costly as other sets of licenses, whereby they may well be contentious. They require a report to be presented to the licensing board, and there may be a requirement for a hearing or indeed subsequent action in relation to that. The approach we've taken in relation to fixing fees is that we have calculated a mean average of the calculated fees. The legislation provides that each application of a specific type should be charged the same, so therefore, regardless of the time spent processing an application or whether an application requires a hearing or other subsequent actions, the principle is that the fee that is charged should be the same. So that's why we have taken the approach of calculating a mean average. So essentially, for want of a better terminology, and this might not be very eloquent, but essentially splitting the difference between those number of applications for which they can be dealt with simply either under delegated powers or are relatively straightforward, compared with those where they are contentious or if they do require further procedures. So, for example, taking those matters to the board or matters that require a further hearing or hearings to be undertaken by the board. So in terms of the evidentiary documentation that you have before you, there are a few appendices which are also applied in relation to this. Appendix 1 is the proposed consultation wording itself, and as previously stated, this would be what we'd be looking to circulate through our Engage platform, and indeed would also be looking to engage with colleagues in our communications team to make sure that the awareness of the proposed consultation will be made aware to the general public, and indeed will also make overtones to the licensed trade to make sure they are aware of this as well. In terms of Appendix 2, you have in tabular format a summary of the current fees which are charged by the licensing board, the proposed fees that we will be looking to implement from the 1st of April 2026, and in the third or fourth column, I suppose, in that regard, a national average comparator. And then Appendix 3 goes into a little bit further detail in relation to what those precise fees are for those other licensing authorities in Scotland that we've been able to obtain information of their fees for. So finally, in summary, because again, I think it is probably incumbent upon me to acknowledge that in relation to a number of the fees that the licensing board currently charge, and indeed in terms of increases that we would be proposing in terms of this consultation process, they are in many respects larger than the national average comparators. All I can really say in relation to that is the calculations that are put forward in relation to the fees that we charge are nothing more or nothing less than a reflection of what it actually costs the council. And I say the council in this term because I appreciate that the board is a separate entity, but in terms of the processing costs of that, in terms of officers, that's obviously supported by officers within our licensing team and indeed obviously the likes of LSOs and other supporting services as well. So in terms of the cost to the council in order to provide that, we have based those fees upon those costs, nothing more and nothing less. So with that in mind, I would be happy to put that back to yourself, convener, and be happy to field any questions of board members.
Okay, thank you. Any questions? I would just say that, just take a note, the variation in fees between local authorities is quite interesting when you see them tabulated like that. Mr Goodall, please.
Thank you, Chair. I'm quite concerned about what you've just mentioned. If you look at the fees that we are proposing to charge and compared to other areas, when the one I'm looking at in Appendix 3 is the transfer, which is for us all 315, and in East Lothian it's £37.50. So the question is, how can they afford it to do it at that level if they are covering their costs? Can we take it that they're not covering the costs and the fees being subsidised by input from elsewhere in the council or somewhere else?
Thank you, Mr. Goodall. I think the first thing I would say is I don't necessarily want to speculate in relation to how other licensing authorities are approaching those matters. What I would say, and I would come back to the final point that I made before coming back for questions, the fees that we currently charge and the ones that we are proposing to implement for the subsequent years, they are based on what we have found to be the cost of providing that. It is purely a case of what we have calculated as the fees to cover the costs of what we are doing. It may well be the case that, and I know we had previous discussions around this with officers and indeed the convener and the vice convener. It may well be the case that I think we're certainly aware some licensing authorities may well not have undertaken reviews of fees since the legislation first came into effect 20 years ago or so. So it may well be some licensing boards have just decided that they are going to retain the fees that they've historically had. It may also be the case that some licensing authorities have taken the position that they are willing to subsidise or bear the brunt of a cost in order to maintain the fees at the level that they have provided. But again, I would just come back to the point that what we are putting in front of members today is what it costs the board or Aberdeenshire Council more broadly in order to be able to provide those licensing services. And the other aspect I probably would want to state in relation to that, obviously it's not for members to decide today whether they actually want to implement those fees. There's obviously, if members are happy for this to go forward to consultation, we can obviously obtain the responses of the public and licensed trade in relation to that, and you can come to that determination afterwards. But I'd also say to members, if members were to be minded that they did want to have set lower fees than what we are proposing, subsidising those costs don't come in isolation as well. You're obviously making a decision in relation to the licensing board, but obviously if we get to a situation where we're not covering costs, those costs have to be absorbed somewhere, and the reality is they're probably being absorbed elsewhere within Aberdeenshire Council. So just for members' awareness.
Okay, thank you. I think we are used to the principle of full cost recovery in other council services. So, but just remember today, this is only to agree the formal consultation process. We're not actually setting the fees today. Mr. Menard, please.
Yes. My only concern is, like I say, Martin, is we don't seem to get the message out there about consultations and everything else. Can you please ensure that we do get the message out there? Because when you look at some of the responses we've had in the past, not only from the surveys that you put out, but other council officers have put out for surveys, and they're incredibly poor. And then we get the backlash further down the line because people have said, oh, we didn't know this, we didn't know that. So is there any other way that you can maybe step out of the box a little bit and make sure that this survey goes out, or this consultation goes out to the wider field, wider public, you know, because like I say, we'd like to get then we can justify whatever we decide to put out at the end of the day, because we've had a full consultation. Thank you.
Yeah, thank you through the convener. Thank you, Mr. Maynard. And yes, all I can say is I would certainly commit that we would endeavour to do what we can in order to advertise the public consultation to the extent that we can. Obviously, that main platform is through the council's Engage forum, but again, we would obviously look to endeavour to promote that within the contacts that we have within the licensed trade. And as I say, I would also be looking to probably engage with our communications team to see if there's other avenues that we might be able to explore in order to make sure that that's as made widely known and widely available to people as we possibly can.
Okay. And there's always the issue that even though the surveys are out there, people don't always fill them in. Okay, no more questions. So in that case, can I just take you to the recommendations then? The first one is to agree to the formal consultation on proposed changes to certain licensing board fees as detailed in the report and in Appendix 1 to the report between the 3rd and 30th of November 2025, next week. And the second recommendation, do you agree that the results of the consultation exercise be reported back to the licensing board in December, I think it's the 17th, with a view to introducing any changes to the fees from the 1st of April 2026? The board agree?
Agree.
Agree.
Agreed.
Yeah. Okay, thank you.
Thank you, Convener.
So we now move on to 8B, which is a review of the statement of licensing principles in relation to the Gambling Act 2005, and this is the final report. So I'll go to Fiona to take us through the report, please.
Thank you, Chair. I think you'll be quite glad that this is the final report. It seems to have been quite a lot of reporting to the board on this, given our timeline. We have updated our timeline and we have met the terms of our timeline, I'm pleased to say, so we're asking you to note that. We're also asking you to consider the responses that have been made to consultation, which are set out in Appendix 2, summarised in the report. There are very few responses. That is normal for a gambling policy review. The ones that we have had, we've been able to answer all the questions, and also we've had praise for the way that our local area profiles are set out, but I'll come to that later. So it's not unusual for a small response to be made in relation to the policy. None of them none of the responses asked for any changes to the content of the policy or said that the changes that we had proposed were wrong. So the finalised policy is very much as the draft that we put out for consultation. We have put in a version control document and we have added an appendix which sets out the changes that we've made and the responses that have been made to consultation, so it's out in the public domain. My apologies for the late circulation of the approved integrated impact assessment. Didn't manage to get that done until yesterday. However, there was no change to the IIA following the consultation, and I did summarise the positive and negative impacts within the body of the report. The only negative impact is that as a result of the growth of online gambling, which falls within the remit of the Gambling Commission, there are some gambling operators that are closing down their premises and moving solely online. And we have no control over how an operator operates their business and whether they remain within our town centres as booking offices or bingo halls, or whether they close those premises down and move online. So it's a negative impact that we're unable to mitigate because it's out with the board's control. So we're asking you to consider the terms of the IIA, approve the terms of the policy statement for the period of 2025 to 2028, and we're also seeking the usual authorisations for the clerk to publish notice of the approval at Woodhill House and in all public libraries to make sure there's an electronic copy of the policy available for members of the public to access from the 7th of November to the 5th of December, and then thereafter to authorise us to put in the statutory notice in the newspaper of the fact that we have reviewed the gambling policy and to publish the revised policy online. And finally, in relation to the area profiles, we have been gathering additional statistical information via Power BI that we're exploring putting into the area profiles to enhance them, but we need a bit more time to do that. And given the area profiles don't sit within the policy, they sit alongside the policy, we're asking you to note that we are doing the work and we hope to bring the revised area profiles back to either the December or the February board, depending on how much work is involved. We also plan to put in a timeline for the next review now, so that we're able to hit the start of 2028 with a revised policy rather than near the end of 2028, as we've been a bit behind this year and the last time we reviewed as well. So we want to put a timeline in place now that will sit within our 5-year plan within the governance team to make sure we kickstart the next review well within time to meet the deadlines required. With that, I'm happy to answer any questions, and I'll put you back to the chair.
Okay, thank you. Any questions on this paper? Tremendous amount of work goes into this. Ms. Black, please.
Yeah, no questions really, just a comment, like you've just said, convener, that, you know, the amount of work that has gone into collating this and doing those local profiles and putting the whole policy together is tremendous. So just thank you very much for all your hard work, the whole team, to put something in front of us that is very easy for us to approve. Thank you.
Yeah. I think it is worth commenting on that as well. It's a very readable document. Mr. Menard, please. You're on mute.
My mic keeps shutting itself down. Likewise, I echoed Miss Black's and your sentiments. Well done, hard work, but it's paid off. It's a readable document, easy for somebody like me to read and understand, and I commend you for it all. Nothing but praise. Thank you.
Thank you.
Okay.
I'll make sure that feeds back to the whole team, Chair.
Okay, so I'm not going to read out the long list of recommendations. I think, can we just agree the recommendations as written?
Yeah.
Agreed.
Agreed.
Thank you.
Okay, and thank you. Come to the final item. It's the date of the next meeting. The next board meeting is set for the 17th of December. Can members please note that date? And I can confirm the meeting is now concluded and the recording will be stopped. Thank you for your interest in this business and your participation in the meeting today.